A lot of you are talking about Blake Lively's motion to dismiss, and you're worried that this Me Too law might actually dismiss Justin's defamation case. Well, we got one of the best employment lawyers here in Hollywood. Stay tuned. Welcome to Popcorn Planet. I am Andy Signor. Guys, I'm so happy we got Ron Zambrano here. Welcome, Ron. How you doing?
Hey, Andy, how are you? Thanks for having me back.
I can reveal Ron is in our documentary, guys. When I was out in LA, I got to interview Ron in person. He was so fantastic. I cannot wait for you to see his longer portion in that documentary where we went into details. But Ron, just to hype you up, you're repping the Dancers Against Lizzo. You're currently in the Soldier Boy case. You rep a lot of these employment Hollywood celebrity cases. Yes, so this is in your wheelhouse, all the stuff that we're referring to.
Yeah, this is my wheelhouse. I love talking about it.
Well, I'm glad you made time today. Thank you for fitting us in. And I'm glad because this one's confused me a bit. Okay, a lot of us, my team, everybody, we're all sort of thrown for a loop by these new laws. And I figured you'd be the man to really help us break down what's going on here. For those that don't know, Blake Lively, following Ryan, have now put motions to dismiss, and they've invoked this Me Too law in a bid to throw things out. This special law, it's Civil Code 47.1, which we have right here. It's a new provision that was added during the Me Too sort of phase to seemingly help people, during this era to not be retaliated against. She's invoked this claim in the lawsuit against Justin. And I guess I want to start right there, Ron, with your opinion. Is this addition a worthy addition, and could it throw out Justin's case?
I don't think there's a very good chance. These types of motions to dismiss on the basis of these laws, which are very, very important, are really designed for truly frivolous, malicious acts meant to silence people, meant to intimidate people from coming forward. The problem is that, and maybe this is by accident or intentional, but Baldoni's lawsuit is so just saturated with text messages and interviews and he has a good, what I believe is a good faith basis, and this was not done in bad faith, which is one of the things required for Lively's motion to dismiss under this California statute. And I don't think it's a very good chance. I mean, it's a good try, but I don't think it's a good chance.
So here it is, Civil Section 47.1, which bars retaliatory lawsuits based on public disclosures of SH and related allegations, including disclosures to the press. She's basically saying, well, them suing me is retaliatory because I made a sexual harassment claim. I mean, it's kind of absurd, implying that no one can defend themselves from an SH claim. It's almost like the silver bullet, if you will. Well, Ron, you touched me funny. I made the allegation. You can't fight me back or sue me back. I mean, it seems like that's what she's implying here.
It is what she's implying. And the problem for her is that, we're all going to speculate how the New York Times got a copy of the Civil Rights Department complaint that, as you know, we talked about, should never have come out in the first place. That was weird. The problem with that is that she opened the door for that type of details to come out. And so a judge will be like, listen, this really did happen. And he defended himself, not in a very benign way, but with his own evidence. And you're invoking this law, but I don't see any malice in the counters in Baldoni suit because there is a lot of evidence that maybe this isn't with maliciousness. So judges by design are not there, and they want to avoid having to make decisions of fact, right? Who's telling the truth, who has malice in their heart. There's enough here for me, the judge, to see that a reasonable jury can find one way or the other. And if there's a tipping balance of fact, I'm not going to kick it away here. So it's a very high burden. And it should be really, but like you said, this is really designed for when people are called out, like, give me the basis for your lawsuit. And if they can't come up with anything, those cases should be kicked out because those are really meant to intimidate people from coming forward.
So the other thing that's interesting is about how she's suffered massive damages after this. Reputation she's suffered result of Wayfair's party's meritless and retaliatory lawsuit. What's really interesting to me is I haven't seen that. She's been on red carpets for her movie premieres to not much, issue. She's now doing a Nat Geo documentary, which doesn't seem like she got fired from. She's at SNL 50 being celebrated, making joke about it. I mean, does all of that hurt her case as well?
Yeah, so there's two ways to view it. One is the way you're viewing it, which is in reality, is she really being damaged? The second one is, well, if he was just saying this in the press, you couldn't file a counterclaim, and you wouldn't. There is no damages, right? So it's kind of like she's trying to get her cake and eat it too, because he could have been defending himself and released these things to the New York Times, and she wouldn't have been able to file this quote unquote counter, well, not motion to dismiss, or kind of counterpunch, let's call it, because he wouldn't have filed the lawsuit. So it's really like no harm, no foul. It would have been the same thing anyway.
So that she's like, what's just weird, she's playing this victim, as her own sort of lawyers are saying. In an epic self-own, the Wayfair parties have created more liability for themselves by their malicious efforts to sue Miss Lively into oblivion. Sorry, I'm trying to read. She's sorry, they always never put the quote. The painful reality is that Miss Lively is not alone in being sued for defamation after speaking up about being SH'd at work. Miss Lively has suffered greatly by speaking up and pursuing legal claims. It is important for other people to know that they have protections, and that there is a specific law that is expressly protects them from being silenced or financially ruined by a defamation lawsuit because they have no courage, because they have the courage to speak up. But I just find this so despicable, because who's silencing her, and how has she been financially ruined that's provable in your eyes? I mean, is this all just PR tactic, or do you think there's any basis to what she's saying here?
Um, without delving too deeply in what you and I discussed in the initial interview, she's trying to control the narrative that she has lost with Baldoni's countersuit and the massive amount of stuff he put in there. This is her attempt to claim the, get the high ground, let's call it, in the PR war. And it is the problem is that this is a product of her own doing. No one feels sorry for her. I don't think anyone's going to feel sorry for her. Like, oh, you're a victim. Well, you count, you made this huge deal, and you opened this door, and he came out with his own evidence, and now you're upset about it. It's I don't think it's going to play well, one, in in public opinion, but I think the judge is also going to see this as like, yes, I understand this statute, but you do not fit it because of what I'm being presented evidence wise, that what Mr. Baldoni is doing maliciously, because this is all very strange that the New York Times got this article, and there's text messages that are incomplete from your complaint. Maybe this isn't malicious. Maybe your statements were not in good faith, and that's what she has to do in her motion. So what this is going to force, though, for everybody that is listening, is that his opposition has to basically be, he has to try his case on paper, with declarations from people, declarations from witnesses, and also the text messages to show that he wasn't acting maliciously. And I imagine you're going to call me back when that happens.
Well, the other thing I want to bring up is, because you're California based, you deal with this a lot. It's a lot harder when these defamation cases out in California, correct? That's why Johnny did in Virginia during that trial, et cetera. Is that part of this as well? And do you think she could succeed there in trying to push a lot of this, which is currently New York based, back over to California law to sort of make it tougher for him to win? And is that something she could actually win?
I don't think so. I don't think the chances shift in any way just because she's citing California law. At the end of the day, these judges, especially in New York, and a lot of contracts that are entered here in Hollywood have a New York venue provision. These judges are very well versed in the things that keep coming up, and these defamation claims do keep coming up, and then the counter punches to defamation claims keep coming up. This judge is going to be very, very competent in this, and he's going to apply the law, which requires a showing of malice, which I don't think she's going to be able to undo once Baldoni's opposition shows all the things that may prove, and a jury will be allowed to ultimately listen to, that she was not doing her initial complaint in good faith.
Right. As soon as she went to the New York Times, as soon as we've learned now with the metadata that this has all been going on for months before then, she's acknowledging and sort of doing what she's alleging he's done. If she had done this privately, I imagine, and done it the proper channels and not made it a big to do, he probably would have had a tougher time. No?
Yes. Her conduct, the real problem is she's not conducted herself in a way that is consistent with someone who is a victim and speaking up with her rights. It sounds like she it reads, at least initially, that she was trying to use the legal system inappropriately to try to bury and put Baldoni under a rock, um, and it didn't work.
You told me something I remember, and we were doing our interview. Which, stay tuned, guys. It's a doozy, and thank you for saving some of it, if you will. But you did mention, like, federal court's no joke, right? Compared to the state court, federal court way tougher. Now, Justin's lawyer saying Blake's abusing the legal system, slamming the motion. We'll get to this comment in a second. But is there a version of this where these dismissals, even from Ryan's out there as well, claiming that Justin's thin-skinned and, basically admitting to all that he did, and they're all just trying to just throw these cases out. Could this actually do damage to their case, or the judge is like, dude, this is not going to get dismissed. Why are you wasting the court's time, or is this all standard?
Yes, this is very standard, one, but two, federal judges take a more, I would say, practical approach in what they're reading. They like to cut through the BS, let's say, and they will see things as for what they really are. They will see the subtext within the bounds of their rules, and they see what's going on. Like, initially something came out through the New York Times, fine, but it was a complaint, and it's something that Mr. Baldoni was allowed to react to, and he didn't react in a very petulant way. He came out, with every single possible piece of ammunition at the ready and in his lawsuit, which also is very unusual. Everything about this is very unusual. And the judge is going to see that someone here is wrong. And at the end of the day, his job, the judge's job, is to allow a jury to decide, not for the judge to be like, oh, I'm just going to take a side and kick this out. Because I do not think the judge is going to find that what is required for the 12b6 motion by Ms. Lively meets the standard under the California statute she's trying to rely on.
Brian Freeman told TMZ Ms. Lively's recent motion to dismiss her from reason to dismiss herself from the self-concocted disaster she initiated is one of the most abhorrent examples of abusing our legal system. Stringent rules are put into place to protect the innocent and allow individuals to rightly defend themselves. Laws are not meant to be twisted and curated by privileged elites to fit their own personal agenda. What do you think is his statement? Is he right on the money on that?
I think, well, for purposes of being the advocate and the person who signed the document that is being attacked, it's a very good quote. But putting it plainly and legally, he is right. There is abuse of these laws. There is abuse for self-serving abuse where that things shouldn't be brought up. On the one hand, victims of sexual harassment should be free and not have fear of being, sued into oblivion because they're trying to come forward with their experience of trauma. But at the same time, and that's why there is qualifications to invoke these protections. At the same time, you're not supposed to abuse it. And I think he, within his role as an advocate, is saying that very vehemently.
Well, I guess we talked about this, and you'll see it in the documentary. Stay tuned; it's worth it. I don't mean to keep hyping it, but I got to hype it because it's good. We got a lot of people, experts, including Ron. So support our Patreon. That's the best way to make sure you get ahead of it. But I do want you to sort of elaborate again as we wrap up here. Is what she's accused him of actual sexual harassment in the state of California in your eyes? Like, is that going to come up as a problem as well? This sort of ambiguity of he called me sexy and James was looking me in the eyes while I'm breastfeeding and sort of these things that she's now leveled against him. Do you feel like that is all still sexual harassment in the state of California?
Right. So I have a memory of, with putting everything that I've read, right? I don't know what's actually in the lawsuit off the top of my head, but everything that I've read, which is what you brought up, it can be, for purposes of a judge kicking it out or not, the judge is going to say, at least under California law, listen, every person is different. A jury has to decide whether it's severe, right? Like touching boob is severe, or pervasive, which is something that's not touching boob, but happening over a course of time. And the judge is going to see one of those have to be pled. It might be it. The problem is that it might be true, it might be not true, but there's this underlying subtext where she went so hard with regards to incomplete text messages that Baldoni's provided the complete text messages, that I believe the judge is going to be very upset at Lively at trying to defraud the legal system that way. And judges don't like it when they catch a party in a lie.
Right.
And trying to fool the legal system is something judges do not like. The judge is like, listen, people can have two versions of the story, but you picking and choosing things and trying to fool me in your filings, no, I'm not going to have it. And that may be the problem, because he or she will be, that judge will be more difficult on the party who tried to fool the judge.
Right. Those texts, the video evidence, that stuff's going to come into play and help it. But yeah, so the harassment though needs to be severe, extreme, multiple cases. The all of which she's trying to put together in her complaint is what could clarify it. It's why she has so many sort of little allegations. I'm guessing, right? Because the broader general allegations together as a whole more effective than any of those allegations singularly.
Right. Right. The idea is, if you don't have that one, the super terrible thing, the grab boob thing, for example, or sexual assault, which is a lot of cases I have, if it's things that in a vacuum would not rise to the level, but you can say they happened consistently over time, which takes more lawyering and very good witness, then yes, that meets the standard under California law for sexual harassment.
Now, does the fact that the film finished successfully after she brought together her allegations, which she's calling the complaint, but it was really a return to work engagement is what it was. And then everything ceased to be fine, which both Blake and Justin have acknowledged. Is that also going to potentially hurt her case?
Yes, because it goes to her ability to say she's damaged in any way. She can't, it goes against her ability to do that. So then it becomes an emotional distress case. And not to get too far into it, but she becomes an open book, and her friends might become an open book. She has opened a very serious door that may affect her personal relationships with people that may not want to be involved.
Yeah, we talked a lot in great detail. It's going to be awesome when you guys see the full scope of our documentary, getting into all the nitty gritty, which the other ones aren't doing because they just want to rush it out. We're doing it right. So stay tuned. Ron, always a pleasure. Thank you for making time this morning, fitting into your busy schedule. And I know you're doing a serious case, which you had to get into this Soldier Board case, which I've been looking into as well. Would love to have you back. Any of these cases you got, let us know. Thank you so much for being here. Make sure you guys hit the subscribe button, hit that bell for all alerts so you get notified, smash the like as well, and leave your comments and theories down below. So overall, Ron says, look, it doesn't really matter to anything. None of this is going to get thrown out. Is that the bottom line I'm getting from you?
Yeah, that's my read. And I think it's her fault the way she started this.
Well, so there you go. Quit getting worried, everybody. All you Justin fans. Looks like the thing is still going to keep moving forward. Stay tuned. We have a lot more coverage coming your way. Appreciate you guys for watching, and stay tuned for more.